Hello, this is VNSS, and in the last video we discussed about the three new bills that were recently introduced in the Lok Sabha. Last video we discussed in detail about the Bharatiya Nyaya Sanhita bill. In this video we are going to discuss about the Bharatiya Nagarik Suraksha Sanhita bill and the changes that were made in the bill, and along with that some important judgments. Everything we will discuss in this video. Bharatiya Nagarik Suraksha Sanhita Bill 2023. It was also introduced in Lok Sabha along with the other two bills. As you all know that it is going to replace the Code of Criminal Procedure which was introduced in 1973. Before going to discuss about in detail about this new BNSS bill, we will just talk about what is actually Code of Criminal Procedure is, what it deals with, what this code actually deals with. Actually, this Code of Procedure, whatever was there, Code of Criminal Procedure, it provides the code or procedure for arrest, prosecution, and bail for offences under various acts, including the acts which were under the IPC Code 1860. So in IPC, it provides the offenses and the punishment. Here, it provides the provisions like procedure of arrest and bail for all the criminal activities. So the new bill BSNS bill, it retains most of the provisions that are present in CRPC code, but there are some key changes which were made. So first, we will discuss about these key changes in this video. The first one is detention of under trials. Actually, in the present code or CRPC code, if an accused has spent under detention half of the maximum period of the imprisonment for any offense during the investigation or trial, he must be released on his personal bond. That what exactly this statement means is, you all know that India, one of the main problem India is facing is the number of pending cases. India has lot of pending cases. Even Supreme Court, in front of Supreme Court, the number of cases was holding a record. It keep on increasing every year, and people are trying bringing new systems like moving trials, online trials, whatever they are trying new systems, but still the number of cases being keeping on increasing. Just imagine a person's case was in court and investigation was going on, but and the maximum punishment that the offense he was arrested would be for 6 years. Imagine, and he spent 4 of years in imprisonment under detention, and his case was still on investigating in pending in front of court, and later in court it was proven that he is innocent. Then it's just like an innocent person was being in jail for 4 and 5 years, which is a big thing, which is not something which we can leave it. So to tackle that, this thing was there in court that if he spent the half of the maximum period that he would have been imprisoned under the offense, he should be released under personal bond. But but in the code it mentioned that this will not apply to the punishment which is having the death punishment or hanging punishment or death punishment. So what this new bill added is, it also added one provision that the existing provision will also not apply to two more things, two more categories. One is the offences which are punishable by life imprisonment, along with that life imprisonment, and also to the persons against whom the proceedings are pending in more than one offence. Like, it is not the only offence he is arrested on, there are more offences which are pending under his name. So for them also this provision will not apply. And it also adds one more thing, that is the first time offenders, who are the first time offenders are there, they will be released on bail if they complete detention, one third of detention of the maximum imprisonment which can be imposed on the offense they were arrested on. So if they spend 1/3 of the period of the maximum period of their offense and they are first time offender and their case was still pending in court, then they can be released on bail. So if they has to release on the bail which are on under trial, then at least the superintendent of the jail, at least the superintendent of the jail has to make the application seeking for the release of that person. Second one is trials in electronic mode. As previously we discussed that about the Supreme Court pending cases, so this is also one of the relief kind of thing, one of the provision to tackle those pending cases. Here what it says that all trials, inquiries and proceedings can also be held in electronic mode. And it also does, this bill also provides for the protection of electronic communication devices which are likely to contain digital evidence for investigation, inquiry and trial. So what actually this electronic communication includes means it also includes the communication through devices such as mobiles, computers or telephone, etc. So this is trials in electronic mode. Coming to the third one, medical examination of the accused. So the existing code, the criminal procedure code, what was there, it actually allows conducting of medical examination of the accused in certain cases, including cases of rape and all. Such examination should be carried out by a registered medical practitioner, not by any other person, on the request of at least it should be an SI level police officer. If he requested only, or higher officers or minimum SI level. So if they requested only, the examination could be done. But now in this bill it provides that any police officer, any level of the police officer can request for such an examination. Next one is forensic investigation. What this new bill mandates is that forensic investigation for offences which are punishable with at least 7 years of imprisonment. So it mandates the forensic investigation is compulsory for the offences which are punishable with at least 7 years, minimum 7 years imprisonment was there. What it clearly means that forensic experts will visit the crime scene, they collect the forensic evidence and record the process on mobile phone or any other electronic devices. So if any state doesn't have the expertise or doesn't have the technicians in forensic department, they can use the forensic utilities and facilities of the other state. Actually, so many states are facing this problem of not having forensic equipment or technicians in much needed number. And the next one is power to prohibit carrying arms. So, what actually is power to prohibit carrying arms is that the code, the existing code, whatever is there, it actually empowers the district magistrate to prohibit the carrying of arms in any procession, mass drills, or mass training with arms in public places. So, this may be done to preserve public place, public safety, or maintain public order. So, these prohibitions can be done in place up to 6 months actually. Maximum 6 months can be done. The present bill omits this provision. It cancels the present provision. It didn't take this provision into the bill. And the next one is signatures and finger impressions. The existing code, the present CRPC code, it empowers metropolitan or judicial magistrate to order any person to provide specimen signatures or handwriting. Such an order can be given for any investigation or proceeding under the code, present existing code. However, such specimen cannot be collected from a person who has not been arrested under the investigation. It was there in the code. But what this bill extended is it extended that this to include finger impressions also and voice samples also. It included along finger impressions and voice samples along with signatures and handwriting. So these samples may also be taken from a person who has not been arrested. In code, actually person who is not arrested, from them we cannot take any kind of samples, but here we can take in the new bill. Next one is timelines for procedure. The next key change happened in this bill is timelines for procedures. Actually, this bill prescribes some timeline for various procedures, like it requires medical practitioners who examine the rape victims to submit their report to investigating officer within 7 days. So this bill has given some timelines, specified timelines for medical practitioners to submit their report within that specific time to the investigating officers. And there are some other specified timelines, example like giving judgment within 30 days of completion of arguments. It can be extendable up to 60 days in case if it is needed. And they also has to inform the victim of progress of the investigation within 90 days. Within 90 days they has to inform the victim till where their investigation reached. These are the provisions in the new bill. And the next one is trial in absence of offender. So this new bill provides for conduct of trial and pronouncement of even judgment also in the absence of proclaimed offender. Even the offender is absent, the trial can be done and the judgment can also be announced. So this can be done when this can be done when such a person has absconded to evade the trial or there is no immediate prospect of arresting him. So if he ran somewhere or something. So what this proclaimed offender means, actually proclaimed offender clearly means that he is the person who is accused for an offense which is punishable with imprisonment of at least 10 years or death. Then he is known as proclaimed offender. Or if he fails, and along with that, if he fails to appear at a specific time and place as specified by the court. So these two cases, then he is claimed as a proclaimed offender. And the next key change is metropolitan magistrates. The code empowers the state government to notify any city or town with a population of more than 1 million as metropolitan area. So such areas have metropolitan magistrates. So this bill omits this provision. So in this new bill, this provision was not there. And one more provision which has actually raised the eyebrows of the critics is that the increase of the period of police custody exceeding 15 days. So as providing in CRPC, so the police custody period is normally 15 days as per CRPC, but this bill had extended that exceeding the timeline of 15 days. But this helps the police to investigate the case more, interrogate the accused person if any additional evidence has found against him. But there are also two caveats to this provision. First one is there must be adequate grounds to permit the extension, and second one is the 15-day limit which can be exceeded only after the initial 40 days or 60 days out of the total detention of 60 days or 90 days. When he already spent that much time, then only it can be extendable. And it also depends on whether the offense is punishable with imprisonment of 10 years or more, and the accused is still eligible to release on default bail after a total detention of 60 days or 90 days as provided in the CRPC code only. So this discretion to permit additional police custody, it resets with the judiciary itself. It is not in the hands of police, it is laid in the hands of judiciary. It can only decide whether the custody can be extended or not. It also enlarged the scope of judicial inquiry into suspicious deaths. So, by including dowry deaths, such that also it enlarged the scope of judicial inquiry. But it also, what it did, it also relaxes the compulsory or mandatory recording of statement of a woman or a male who is under 15 or above 60. So, at the place of their residence, based on their willingness, they can't force them to do record. If they are willing and at their residence only, they can do such recordings. So it was mainly introduced so that police should not misuse their power against women or children or elderly. Their power they should not misuse. So for that case, this provision was introduced. And for elderly people, here there is one more provision that was introduced in BNSS is that offences which are punishable with less than 3 years of imprisonment. So in that cases, arrest can done only with the prior permission of DSP if the accused person is infirm or is aged over 60. So, this may provide some relief to those two categories of persons, which are provided the Deputy Superintendent of Police uses the clause judicially. And handcuffing, coming to handcuffing reasons also, the new code provides handcuffing in at least a dozen categories of persons who are accused for serious offences, inter alia such as one who commits a terrorist act, murder, rape, acid attack, or offences against the state. This is sure to help the police who may be short staffed to secure their custody. But this enabling section that guides handcuffing has not changed. It says that the person arrested shall not subjected to more restraint than it necessary to prevent his escape. So the investing officer still has to justify the handcuffing with the possibility of escape when such criminals are produced before the court. So the preferred use of electronic devices, as we discussed before, has its limitations still. For example, we will take some Supreme Court case study. So the Supreme Court in Shafti Mohammed versus the state of Pradesh 2018 court directed that the Ministry of Home Affairs and states to develop facilities for the videography and photography of crime scenes during the investigation at the level of the police station. So, a pilot project is in progress, and this needs to be taken forward to ensure that the provisions of the new code are implemented in their true spirit. Here, at the level of the police station, is the crime. What is the primary statement we have to keep in mind? So I hope we discussed a lot, and if there are any mistakes, please kindly excuse me, and hope you all enjoyed the video. And if you want to add any new things, any new cases that were related to these CRPC and BNSS code or any three bills, you can kindly mention them in the comments. And this comment box is like your discussion forum where you can do discuss. And I recently changed my channel name to Venus Har UPSC. Hope you all like it, the new name, and kindly like, share, and subscribe the channel. And hope you have seen the G20 video. If not, please do visit my channel and see the G20 video and the previous BNS video too. And in the next video, I will discuss about the last bill, the third bill, Bharatiya Saksha bill. So thank you. Till then, enjoy your